morning. Please help yourself to coffee if you haven't done so already, sponsored by Dunkin' Donuts. I am going to turn things over to Chris Corpus. I'm sure some of you might know who he is. And he's going to talk about general contract overview. So Chris, turn things over to you. Thanks.
All right, thank you everyone. So I have a handout on the table that'll just kind of track along with the presentation that's on the overhead, or on the, yeah, it's telling you how old I am. I'm talking about an overhead projector. But if anyone has any questions, so we're just going to have a kind of a general legal overview, general legal talk. If anyone has any questions about a topic, even if we're not talking about that issue, feel free to bring it up. Because most small businesses, whether you're a landscaper, you're selling a service, you're selling a product, when it really comes down to it, for the most part, your businesses run the same as any other business. So if you have a question or an issue came up, pretty much someone else in the room has either experienced the exact same thing or very well might even have the exact same question. So feel free to just raise your hand and ask a question. Yes?
Is that quick enough? My biggest anyway, when the love is over.
Yeah, so the question was, a lot of times, or it should be almost every time you enter into a transaction, whether it's you're starting a new business, you're entering into a contract with someone, everyone's usually, on the same page. Probably in a good mood, glad we're moving forward, glad we're doing this. But at some point in time, if a relationship sours, what do you do? And, to some degree, you have to try to look ahead into your contract and say, how do we break this up? It doesn't always have to be a bad breakup. The breakup very well could be you're both part-timers. For whatever reason, you're working this business part-time, you're just starting it out. I always like to use the example of a bakery. You're cooking out of it, because it's very simple. You're cooking out of your home, you're selling the stuff at a farmer's market. Not a huge time commitment. But what happens if one partner says, hey, let's see if we can get into Heinen's? Now you're like, okay, now we have some mass production we have to do. And now all of a sudden one partner goes, I just can't spend the time to do that anymore. That's just not what I was planning to spend 10 hours a week and you're asking me to spend 35. I don't have the time to do it. You also could have a situation where my spouse got a promotion and a transfer. I have to leave the city. So it very well could be that you're on good terms, but ultimately you have to, to move. So how do you look in advance and say, oh, how are we going to break this up? And you could have 30-day notice, termination notice provisions. It really just depends on your situation. But you can try to look, foresee into the future, how can we break this up? And because a lot of times businesses do break up and it's a pretty bad situation. People are not happy with each other. You're not going to have a lot of agreement on the back end when you're trying to break up. So as much you can put in on the front end and say, hey, if something goes wrong, this is how we're going to address it. If you're a business owner, it could be, hey, if we're going to, break up, how are we going to value the business? Are we going to use some sort of multiplier of book value? Are we just going to try to come up with a number? If we can't, are we going to hire, someone to do the valuation? So you do want to think of that. I think it's pretty important. Because I was just at a, kind of like an informal mediation yesterday with two business owners, 50-50 owners, and they hate each other. There's no bringing this back. It's over. And so now the issue is, how do you break up? And there's really no real good formula that they put into their operating agreement, pretty basic operating agreement for their limited liability company. And now they're trying to fight over how do we value this business. And so it was a 4.5-hour kind of slugfest. The only thing good is they weren't throwing mud at each other and why they hate each other so much. But it was kind of, and we still didn't finish. And the issue is, does one buy one out? Does the other buy the other out? And if they can't agree, no one can force someone to have their ownership interest redeemed. Even if you offer them a very fair price or an excessive price, they still could say no. And then the ultimate, fallback position is, this business may dissolve. It may become insolvent, and we just got to shut the business down. And so everyone has to kind of have some sort of sense in them. But people can be stubborn. So there's really not a lot. You can put as many provisions in your agreement as you want, but sometimes you have to get the other side to agree to them. But in terms of if you are in agreement, you can try to say, we need to renew after a year. You don't want to enter into a 5-year agreement, keep it a 1-year agreement. Maybe you have the ability to terminate it with 30, 60, 90 days notice, something like that. Because you have to figure, if I have the right to terminate, so does the other side. And are you okay with that person, you ramping up your business, your services, maybe you lease a bigger location, thinking that this partnership's going to work great, and then 60 days into it, they're like, yeah, our businesses aren't the same. This isn't what I thought it was. I'm going to give you 90 days notice that I'm going to terminate. You're like, whoa. I just rented this location for 3 years thinking that this was going to be a very profitable relationship, and you're bailing after 6 months. So you might say that you can't do that, but if someone else can't give 90 days notice to terminate, neither can you. So you have to look at both sides of that equation. If I can do it, so can they. So, any other kind of questions? So it's not part of the presentation that I have that's in front of you, but I've had more and more people come up to me and have issues with the name of their business. They're trying to figure out the name of their business, the name of their product, how to name their service, and it's really hard. You finally come to the, you sit down with maybe someone in a marketing department, a branding role, and you finally figure out a name. You're like, this took me weeks, I've spent a ton of money, and I finally got a name that you like, for whether it's for your company, your product, or your service. And then you're like, okay, let's go with it. And so, I just had a situation where it's a brand new client to me said, I just got a cease and desist letter that I can't use my corporate name anymore, but it's available with the Ohio Secretary of State. So it means no one in the state of Ohio has a name similar to that. So the attorney created their company for them, and now they're out marketing their services or products multi-state. And they get a cease and desist letter, they're like, but I'm allowed to use the name in Ohio. You're like, well, that's maybe true if someone hasn't gotten a trademark from the U.S. Patent and Trademark Office and have federal recognition, nationwide recognition of their name. And so this person gets a cease and desist letter, and now after, I think it's about 7 or 8 years of now building up their brand, and their name is very similar to a federal trademark, and it's in the exact same classes of goods. And so there is a very good chance they might have to change their name after 8 years because that check wasn't done to see if someone on a federal basis isn't already using that name. And all you have to do is you go to uspto.gov, there's a trademark section, you go in there, you search, you type your name in, and it'll give you all the results that come up that are similar to your name. And then you have to analyze it and see if it is truly similar, if it's a conflict, if it's confusing, but ultimately you get at least some information on, hey, am I able to use this name? Because if you are going to start your business up, you're going to spend how many thousands of dollars creating your website, creating your logo, creating your mark, doing all your literature, and then whatever it is, years later, you get a cease and desist letter. Once you make it, again, the bakery example, you're selling at farmer's market, you get into Heinen's, the Entenmann's rep walks down the hall and says, no, that's our name. You can't use that. Then you get a cease and desist letter, and unless you think you can fight it and win, you can try to, but do you really have in excess of $50,000 just to pay in legal fees to try to win? And if you lose, then you maybe have treble damages against you. So most people are looking, if I do have $50,000, I just started out my new business, I really don't want to pay attorney 50 grand just for my name. But, maybe you do have that fight that you want to have. Or do you just start off at the very beginning and make sure you have a name that's not going to infringe on someone else's? So you really want to kind of take a look. So when I help clients, figure out a name of a business, a product, or a service, obviously you have to check the Ohio Secretary of State's webpage. They have a business section you can search in. They have a trademark section you can search in. You want to check the U.S. Patent and Trademark Office because a trademark by the U.S. Patent and Trademark Office, that means you do business interstate. You're doing business in Ohio and in another state or states. So now you're going to have federal protection across the whole entire United States for that name. No one else can use it in your class of goods, unless for some reason you happen to predate them. But then I also, will tell clients, I go just do a regular, Yahoo, Google, some sort of internet search on your name and see what comes up. And then if you're still not sure, there is a service, it's a third party, costs about $650, and you could have them do a search. You'll get a book back about an inch thick, and it's going to tell you everywhere where your particular name or your mark or logo is being used. So it's it's kind of like an insurance policy. You find out exactly what's out there on your name, and then you know whether you want to go forward or not. So it is a little expensive. That's not my fee. That's just the third-party fee to do the search. But it's pretty beneficial for the business owners to know exactly, hey, this is what's out there on my name. Yeah. So the question was, if you do file a trademark with the U.S. Patent and Trademark Office, you don't get that immediately. They're actually going to examine it. They're going to have a examiner appointed. They're going to review your application along with all the other trademark registrations that are in their system. And it could very well take between, the shortest is probably 6 months, very well could take up to 18 months to process your trademark application. But if it's really the first to file. So if you predate someone, so if you file it on August 1st and it's, throw it out there, Corpus law, and then on December 1st, someone else files a trademark for Corpus law, then I predate them. They're going to put the second, the later application on hold until they're going to want to suspend it until my, the first trademark application with that name clears. And once it clears, then that'll block the later application. So it's really a first to file situation. Any other questions? So now you figured out your name, you find that it's available with the U.S. Patent and Trademark Office, the House Secretary of State, and then you go and try to get your domain name. Right? You go on GoDaddy and you type in corpuslaw.com and crap, it's taken. So now you figured out what your name is, but did you want your company name to be the exact same thing as your domain name? So now you're like, okay, do I need to do something different? Do I need to pick a different name so I can get the .com, or am I going to modify my name a little bit? Am I going to get a .net? So now you also have to look at all the social media aspects, and is your business going to be dependent on social media? And if it is, maybe you need to, your name's available, but because the domain name's not available, you might need to change your name. So you really have to figure out what works best for you, what's going to work for your situation. Like for me, corpuslaw.com was taken. There's an attorney down in Corpus Christi, Texas that already took that domain name. So all I did was I did corpuslawinc.com and I have my name. So it's not a huge deal. And I don't do a ton, just based on my business, I don't do a ton of social media marketing. So it's not a real big concern. I think most people that look for me, already know me, or they already have my website address and then they go find me. I don't think a lot of people are just trying to Google and find Chris Corpus lawyer. I just don't think that happens a lot. I could be wrong. So if you are one, don't raise your hand because you're probably, people look at you weird. But anyway, so it really depends on your business. A consumer business where you're selling directly to consumers, you might need to be able to be found easily on the internet. And then once you do find your .com domain name, I tell clients, I go, get the .net, .biz, .org, .info, just block everyone else from being able to get your domain name with the different suffixes. And then you also might say, hey, people misspell my domain name a lot, or they put a the or an or an s on the end. And I also tell them, I go, get the common misspellings. If someone is always thinks my name is thecorpuslawinc.com, I'm like, then I'm going to get the. It's $9.99 a year, and you keep anyone else from trying to get close to you. Now, you can drive yourself crazy because you could put dashes in, you could put underscores in, you could put, and it's just the permutations are endless. But you can get the ones that most, people are going to be, looking at or finding on an internet search. So that whole naming, it's really important because, you spend a ton of time trying to figure it out, and you don't want to get a cease and desist letter, within months, years of you starting up your business, because you just spent $8,000 creating your brand. You probably don't want to spend another $8,000 having to redo your brand. So at this level, you're probably not going to have people infringing on your trademark because people just don't know a lot of the smaller businesses. So a lot of the counseling I do for clients is how to keep them from infringing on other people's trademarks to make sure they start off on the right foot. So naming's a huge issue because you need to get found. The more descriptive your name is of the product or service you're selling, the less protection you have. The less descriptive, the more protection. So if you want to get a trademark in the word in the phrase fresh produce, and your store sells fruits and vegetables, you're not going to get it because it's descriptive of what you're selling. You're selling fresh produce. You can name your business that, you just can't get a trademark in it. But, so I was walking down the street, and I saw a retail store and they had a sign up, fresh produce was their brand name, and they're selling clothing. No one's thinking that you're going to name a clothing line fresh produce, I would assume. So that's a pretty good mark, because you're not automatically making that connotation of fresh produce, fruits and vegetables. It's fresh produce and clothing. Like Apple, the first thing you did think of was a fruit. Now the first thing when you think of Apple is you think of a computer. So that's a pretty good mark. Microsoft, Xerox, things like that, where when you hear the name, you don't know what it means. Those are good marks. When you hear the name and it automatically starts conjuring up an image of what the good or the service is that is being sold, your mark isn't going to be that strong, because like I could I get a trademark in Corpus law, but I can't keep someone else from getting a trademark in Smith law, or Jones law, because I'm describing what I'm doing. And quite frankly, I wouldn't be able to get a trademark in it anyway. But so you have to think, but the problem is the less descriptive your name is of your product or service, the more educating you have to do. Because someone's going to walk by and see the word fresh produce and they think you're selling actually fruits and vegetables, when in reality I got to educate them that it's clothing. So now you have some marketing dollars you have to spend just to educate people what your business even does, or your product is, or service. So, and you have a limited budget, and so you have that kind of dichotomy where I'm telling you, hey, don't be descriptive, but also, be descriptive if you need to, because you don't have a huge marketing budget to tell people what you do. So you just have to realize that in trademark protection, that everyone wants to get a trademark, keep everyone from using it, and never again will someone be able to use that name. And it just doesn't necessarily work that way. So you just have to kind of be careful in that. So then the presentation I had, and I don't know if we're necessarily, we probably won't get to all this, but we were going to talk about business agreements, buy-sell agreements, client engagement agreements. That's like your contract with your customer. It's kind of what I call a client engagement agreement. Purchase orders and invoices, and then employment and independent contractor agreements. I'm going to kind of jump down to the last one, because I think there's a lot of issues regarding whether people are employees or independent contractors. And I think a lot of times people are afraid to have employees, because of all the withholdings you have to have and have to do. And yeah, there are going to be some additional costs on you as an employer if you do have an employee, but payroll is very, very economical. It's very affordable. Misty helped me find someone to do payroll. I think it's, for me on my own, for one paycheck a month, I think it's like $45. Then I said, well, what happens if I ever have an employee? Is it $90? She goes, no, it's like an extra $1.50. So now she goes, instead of being $45, it's like $46.50. So, and they do all the withholdings for you. You just tell them, they do all of that. So it's not like, it frees you up so you don't have to sit there and figure out all your calculations. So from a payroll standpoint, I always tell people, I go, don't make the employment decision because of that, because payroll services are very, very affordable. But then, for an employment, if you're going to hire an employee, in general, the law in Ohio is everyone is an employee at will, which means the employee can quit at any time for a good reason, bad reason, or no reason. Same thing, the employer can terminate an employee for a good reason, bad reason, no reason. The only thing is the employer can't terminate an employee for something that's against the law, whether it's federal or state, or against some sort of public policy. So there are some limitations on the employee at will doctrine and being able to terminate people. So an example would be, you had someone, they've been a great employee, they're 55 years old, you're paying them $45,000 a year. Someone just comes out of school, has a very similar skill set, they're 23 years old, you can pay them, $15,000 a year less. You're like, kind of a no-brainer. Let the 55 person go, hire the 23 person instead, and I just saved $15,000, and then now you got a lawsuit because you just violated the age discrimination laws. So you just have to be careful that you just can't sort of do whatever you want, especially when people have protected classes that they might be in, whether it be based on sex, race, age, disability, and then just because you have a federal law or if you have a state law, now some cities and some counties have their own laws regarding employment laws, whether it be related to pregnancy, race, now you're going to have sexual orientation, are starting to become more popular for different governmental entities. So you really have to be careful about decisions that you make. Employment law is just a minefield. It's going to apply to your small business just as if it's going to apply to a small business. There's a lot of thresholds. Like whether it's the FMLA is going to be 50 employees. But for the most part, most employment laws in the state of Ohio are going to apply to you if you have 4 or more employees. So you don't think that, hey, I'm a small little shop here, or I'm a nonprofit, none of these laws apply to me. Generally, that level's about 4 employees, and all the employment laws are going to apply to you, whether you have an HR department or not. And you're just like, I didn't realize I wasn't allowed to do that. Well, now you do, and you got a lawsuit against you. So employment attorneys can sometimes be kind of expensive to run all these issues by. There's a lot of outsourced HR agencies that can assist you that are very affordable. So that's always an option also. But you can have an at-will or a term of years. So a term of years would be, I'm going to hire you for a year, and they can't let you go, and maybe you can't quit for that whole 1 year that you're going to be working for them, or 6 months or 2 years, whatever it is. So that kind of by putting a term of years in there, it may alter that at-will status, and now they have some rights. The employee has some rights that you just can't willy-nilly terminate them. And then salary, obviously you can, the salary laws are just getting ready to change, I believe, in December, raising up the threshold of who's an exempt employee and when overtime is due. So that's something that, people have to be aware of and consult with an HR agency or an attorney to figure out what type of responsibilities you might have with hourly and salary employees. And then your terms of employment. A lot of times, these issues are the same, whether it's an employment agreement, the agreement with your end-use customer. It's what's their role going to be? What's the scope going to be of their employment? What do you want them to do? When are they expected to do it? How many hours are they going to work? The more clarity you can give, in general, I always say the better. Sometimes people like to have some ambiguity in their agreements, so they have some wiggle room. But I tell people, I go, when you have wiggle room, the other side has the exact same wiggle room. And maybe you want to be able to make an argument in the future that, hey, you were actually supposed to do this or that, or not supposed to do this. But then if there's interpretation that has to be made, whose interpretation's right? And if no one can agree, then a court or a jury's going to decide. Lee Colson's done it before, and he'll say, look at the wall and go, what color's the wall or what color's the ceiling? And everyone's going to give a different color because everyone has a different interpretation of how these things mean, what they mean, and how they're going to apply. So I'll have the conversation up front with the client. Hey, if you want to have some vague terms in your agreement, know that there's going to be a fight at some point in time in the future, possibly, that you're going to have to interpret this stuff. And that's it, whether it's in an employment agreement, your contract with a customer, whoever, or a contract with your partner. And so there's going to be a fight. So you either pay up, you either deal with it now and bring it to a head when it's very inexpensive to have a contractual negotiation now than to have a fight later. So like yesterday, the fight later, I was there for 4.5 hours times $200 an hour. So that's a $900 day trying to figure this out, and we're not done. So it would have been a lot cheaper to have a 45-minute telephone conversation hammering out an issue. But sometimes you just don't know what those issues are, and there's nothing you can do about it. And then your job description. It's very hard to keep someone accountable to what they're supposed to do if you don't have a good job description for them. Because if they don't know what they're supposed to do, how are they supposed to be able to do the job that's in your head for them? They're like, I didn't know you wanted me to do it. If you would have told me that, I would have done it. I just did it my own way. You didn't tell me that you needed it a different way. So, the more specific you can get, I think most people, they like to be rule followers. They want to know what's expected of them. It's just like your kid. You give your kids specific rules, guidelines, boundaries, they generally want to stay within them. But if you just say, hey, come home and then I'll see you at 6 o'clock when I get home tonight and all this better be done. And he was like, I don't know what all this better be done means. So the more specific you can be, I think people generally want to follow the rules and understand what their responsibilities are. And then people love to hire everyone as an independent contractor. No one wants to have an employee like we talked about before. But for the most part, there's some commentators that'll say there is no such thing as an independent contractor. Everyone, if you hire them and you use them on a regular basis, they're all employees. That's a pretty broad brush, but in general, you have to be pretty specific to be an independent contractor. Imagine, when you hire someone who's an independent contractor, the plumber, your toilet's leaking. You don't come in and say, here's how you fix it, and you stand over the plumber's shoulder. You're like, just let me know when you got it stopped leaking and how much it's going to be, and then you're done. You let them do their job. So there's a whole test that the state and the IRS has pertaining to whether someone is or isn't an independent contractor. Usually the problem is when this determination has to be made, it's out of your hands and there's nothing you can do about it anymore. You've let the person go. decent relationship, business slowdown, seasonal, don't need you anymore, and then all of a sudden, the next thing you know, they file for unemployment compensation. And you're like, well, why are you doing that? You're an independent contractor. Well, now the state's going to make that determination whether that's true or not. Person gets hurt while they're at your job on the job site. Now they're going to file for workers' comp. That's why there's nothing you can do about it anymore. This is a set situation that you're going to have to try to prove that they're an employee or that they're an independent contractor. So you really have to look closely and say, hey, do I answer yes to any of these questions that are on the sheet? And so the IRS guidelines, can the worker make a profit or suffer a loss as a result of the work that they're doing? Typically, if it takes them, they say, hey, it's going to take me 4 hours to do this job, I'm going to bill you $1,000. If it actually takes them 12 hours to do the job, who takes the loss? If the person that's doing the work is going to take the loss and eat it, probably an independent contractor. But if you're an employee, you're just going to get paid for the remaining work, and the employer loses out on that bad quote or estimation of how long it's going to take. Does the worker have an investment in the equipment to do the work? Like I have clients that are like, hey, I really want this person to be an independent contractor, but I'm going to give them the computer to use. I'm going to give them the tools to use, et cetera, et cetera. I'm like, well, that's really not the way an independent contractor works. I'm like, you could probably enter into a situation where you're going to lease them the equipment and make them and actually have an agreement that says they're going to pay $50 a month for use of your equipment. Most employees don't have to do that. So you're trying to build up a reason why you say that they're an independent contractor. Does the worker work for more than one company at a time? And employees generally work for one employer. Independent contractors, they just run around and do work for whoever they can get work from. Does the worker offer services to the general public? Hangs out the shingle and said, anyone need a plumber, come hire me. As opposed to an employee is like, hey, I do just work for my boss, and that's it. And then, do you give the worker instructions about when, where, and how to do their work? Do you train the worker? Must the worker do the tasks himself instead of delegate them? Do you pay the worker's assistants or staff? Ongoing relationship, do you do work with them every week, every month? The more you do work with someone on an ongoing basis, typically you're an employee. And do you tell the worker when the person has to, perform their job? It must, if ultimately that person's working 40 hours a week for you and you're trying to call them a contractor, you're probably going to lose. Just because that's just not the hallmark of an independent contractor. Do you control where the person works? So you see there's all these questions that get asked. Must the worker provide you with reports to account for his actions? Do you pay the worker on a regular basis instead of by the job? You pay someone weekly or monthly, the same amount every time, no matter how many hours they work? They're probably an employee, right? Why would you pay an independent contractor if they're not working for you? And do you pay the worker's costs and expenses? Do you provide the work with tools of the trade? Can the worker be fired? Independent contractor could just walk out and say, screw you, I'm done. I'm done dealing with you, right? If you're in a, but if you have a contract, then the independent contractor can't leave, but the employee could walk away. So, can the worker quit at any time? Sort of the same thing with the bullet point above that. So, and then if you answer yes to any of those questions, then it's very well their employee. Just things to consider, because you can, I tell clients, I go, a rose by any other name is still a rose, right? You can't change it just because now you want to call it a lily. It's still a rose. So the same thing with an employee. You can't say, hey, you're an independent contractor, but in actuality, when you go through the test and the factors, they're actually really an employee. So it doesn't matter what your agreement says on the top, employment agreement, independent contractor agreement, it's how you use them is going to be the important part. So any questions regarding any of that? Yeah.
I don't see anything in this about a non-compete agreement.
Sure. So a non-compete agreement, that's a separate document apart from your. So the question was, what about a non-compete agreement? So a non-compete agreement does not have to be in an employment agreement, but it can be. So it's a separate, it can be built into the employment agreement, could be a separate document. So a non-compete is going to basically say, for a period of so many months or years, you cannot compete with the business of your prior employer. And it has to be usually pretty specific on what you can and can't do. Usually it has to be whatever duties you were doing in your prior job you cannot do in the future. But then it also has to have a geographic component to it. if your business is in Avon, you can't say, within the entire Lorain County area, you cannot compete with me, because that's not where your client base is. So if you were going to go to Elyria, you should be able to compete in Elyria because you have no clients in Elyria. All of yours are based in Avon. Or you say in the state of Ohio, you can't work. And you're like, well, really, my business is concentrated in Cuyahoga County and contiguous counties. So you should be able to go to, name a county, another county in Ohio, Wood County up by Toledo, and you should be able to work. So courts aren't huge. Courts will enforce non-compete agreements. People will sign them and go, yeah, those aren't enforceable. Screw it, no big deal. I'm just going to sign it. But they are enforceable. And the part of the problem is the courts will do something called blue lining. So if the employer does say, I'm going to have a non-compete for 2 years, the state of Ohio, and you're like, that's completely unreasonable. So because it's unreasonable, they're going to throw it out. No, what the court does is they take a blue pencil, well, they used to, and they say, we're going to make it, what's reasonable is 6 months, 12 months, whatever. And Cuyahoga and contiguous counties, that's really where they do business. And so now it's going to be enforceable based on a smaller time and a smaller geographic area. So the employer does not have to be reasonable and get it right up front because the court will make it reasonable for them later, which I think is completely wrong because the employer doesn't have an incentive to make it reasonable on the front end. Now maybe they don't get, if there's competition, maybe they don't get an employee because of it because they can go work somewhere else. So they are enforceable. Now you also have a non-solicitation provision that you could have in that. And so that you can go out and start a competing business. You can compete in this, your business was in Avon, your prior employer was in Avon, you could open up across the street in Avon, compete with them, but a non-solicitation means you're not going to contact your prior employer's customers. So you compete, get your own new clients. Now, if you're like in I'll call it a professional salesman, you've been in sales for years and years and years and you have a huge Rolodex that you're going to use and bring with you to your new job. So on a non-solicitation, you could say your new employer might say, you have to agree to this non-solicitation. And you're like, okay, no problem. I agree that as of, September 1st, 2016, I won't contact any of, the current clients that are on your list. Or you could try to say something like, and I'm going to carve out any of my existing clients I'm going to try to bring with me. So then you say, I'm going to agree. I'm not going to, solicit your clients, but I'm bringing with me A, B, C, D, E, F, G clients. And they're going to follow me because of my relationship with them. So they're not going to be part of the non-solicitation because if I leave, I'm going to take them with me because I'm going to continue our relationship. So you can negotiate this. It isn't a one-size-fits-all. The employer gives it to you and you're done. If the employer really wants you and the employer's hiring you because of your contacts, then you'd say, then I get to take those with me when I leave. But you got to do it up front and have that discussion at the beginning to carve them out. And so, then there's also a non-disclosure agreement, which is very common. So those are usually the three. When you think of restrictive covenants, you think of a non-disclosure, non-compete, and a non-solicitation are usually all rolled into one document. Then a non-disclosure is going to be, hey, whatever, kind of internal company secrets that there are, you're going to agree you're not going to take them with you. And a client list is considered a trade secret. It could also be business processes, business plans, things like that. Kind of hard to, pin that down sometimes. But those are usually the three other items. Did that answer a long-winded answer to your question? Okay. Did anyone else have a question? Yeah.
When you were talking about the term of years agreement, so if you're hiring someone, you say it's going to be for 1 year. If after that year, you let that person go, and then that situation arises, and you hire someone younger that's for $15,000 a year less, is that going to be an issue?
Yeah, so the question was, what happens if you have you hire someone for a year, neither side has to renew after the year, and then they're going to be doing job description A, and then you hire 50-year-old employee to do job description A, and you're like, wow, they really did a good job, really no issues with their performance, but I'm now able to hire a 23-year-old to do the exact same job, do job description A at $15,000 less. The fact that you didn't renew, I would think that they would have a claim against you for age discrimination. Even though you do have a term of years, but the fact that you the exact same job is being filled by someone who's, not in the protected class, 40 and above, I think you're probably going to have an issue. And if nothing else, so if an employee does believe that there is discrimination done against them, they can go to the Ohio Civil Rights Commission, and they can, say that they have a claim against that employer. And then the Ohio Civil Rights Commission, if they choose, they can investigate. And then now you might have a claim from the state coming after you. Or they could say, no, we didn't investigate, and then that person could pursue it on their own. But I would be careful, if you are going to, say, if it's not performance related, and you just say, yeah, I'm going to say 15 grand, then I think you might have a problem there. So, any other questions?
Is there a time limit on that? If say
Yeah.
someone believes that happened to them, but they didn't pursue it at the time they left?
I think, and this, I don't practice, regularly employment law. I believe there's a 6-month time period that if you want to go to the Ohio Civil Rights Commission, I believe you have 6 months from the date of termination to go see them. But I believe if you just want to file a lawsuit, my guess is you have a 2-year statute of limitations to bring the lawsuit. I could be wrong, but my gut would be it's a 2-year statute of limitations. And so, kind of continuing to hop around, we have maybe like 5 or 10 minutes. I was just going to quickly go through the client engagement agreement part of it because it's such a huge deal in terms of getting your contract right with your customer. Because think of a situation when you were not happy in a transaction, and why was it? It could be anything. It could be you were supposed to get a product or a service was supposed to be performed by Friday, September 2nd. And then, it comes up, it's not done. It's not ready. And now how do you feel? You're pissed. You're upset. Same thing if someone tells you, hey, this is going to be $100, you hire someone to do something for you, and then you get the item, and then at the end of the month, you get a bill for $500. You're like, whoa, what happened? You gotta be kidding me. You said it was $100. You're like, oh, remember, you asked me to do all those changes. You're like, no, I don't remember you telling me that all these changes were going to cost an extra $400. Or you're like, hey, you sold me this, and it broke after a day. So those are usually the times, everyone's going to be upset when that happens. So I always tell clients, I go, you should really think about addressing those issues up front. Whether it's just in your standard terms and conditions, whether you actually have a discussion with that person, and make sure everyone's on the same page. But those 3 overarching themes are in every contract that you have, and you might as well just address it and deal with it. Because if you're going to be upset if that happens, so is the other person. And if you're the one receiving the service, then you should say, hey, if there is going to be a change in the price, you have to inform me, and I have to agree to it in writing, or something like that, so that all the surprises and last-minute issues you kind of try to get away from. And a lot of that, almost all of that can be addressed in drafting of your agreement. Description. What are you going to be selling someone? What is it? How are you going to describe it? What services are you providing? What goods are you selling them? And you want to be as specific as you can. And if you're buying something, you want to make sure, especially the quality is going to be set forth. Are there different levels of quality of items that you might get? Paint finishes, internal components, whatever it might be. You want to make sure you know what you're getting or what you're selling. And then the price, we kind of talked about it. Be very clear how much this is going to cost. And if they're and then hopping down to the bottom, if there are going to be modifications, in the price, how does that take place? Does it have to be in writing? Or what happens if someone just modifies the price because you made a change? If you're the one providing the service, I think especially I see that happen a lot in marketing, web development, things like that. You provide someone what at the very end of the day, you provide them their website, and you're like, here you go. And you're like, wow, that's really not what I expected. Well, that's what you bought. And I tell clients, I go, have, stops in the middle so that, the other side has to come through and say, yep, I agree with that functionality, I like it, let's continue to move on. Instead of giving someone a final product that took you 6 weeks to prepare, but you had all these, stops that you could have had along the way. And, you build up, what the framework's going to be. Do you like it? Yes, I like it. Looks good. Then you continue on and say, okay, how about this functionality? How about that functionality? And get them to sign off on it and agree. Maybe there's progress payments along the way, so that ultimately you have been getting paid for your work. And then it also alerts you to quickly if you do have a problem. If we're kind of going off track here, this isn't what the client wants now, then you can make a change probably a lot easier at week 2 than in week 6 when you have to completely rebuild it. And then at that point you say, okay, if you want these changes added, maybe now they want e-commerce, and before you were going to use PayPal. That's going to be a whole different ball of wax in terms of creating the functionality for your website. And so now, you say, okay, that's going to extend the deadline by 2 weeks, and it's also going to cost an extra $800. Is that acceptable? Yep, they sign off on the change order, the modification, and you're good. But everyone's on the same page then. And you don't want to get to the end and like, okay, here's all these changes. They still get it in their 6 weeks. And you're like, oh, but remember you wanted a $2,500 website, and when I showed you the Cadillac, I upsold you. Now it's an extra $5,000. And they're like, whoa, 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 whoa! You never told me all this functionality was going to be an extra $5,000. You're saying, oh, there's going to be a small additional charge for that, and the small additional charge was $5,000. And you're like, I didn't agree to any of that, and now you have a huge fight. So it's a lot easier and simpler and cheaper to address those issues up front than to let everything build towards the end, because you're going to have, if you're thinking in your mind, oh heavens, I don't even want to pick up that phone and call them because I know it's going to be a bad phone call. I know we're going to get into it. Would you rather get into it before you invested another $5,000 of your time, or you get into it now and have it up front and get on the same page? I always tell people, I go, that phone call that you don't want to make, it's the first one in the morning. Get it over with and just address it, because it's a lot cheaper to do it now than to wait, because now you maybe never get paid. Are you going to file a lawsuit for $3,000 if that's the difference? Maybe. Or you go to small claims court. Now on social media, so-and-so's a jerk, so-and-so's no good, so-and-so sues their customers when they don't agree with them. And now you have all this bad social media potentially out there against you. And if that's the way people find you, you're like, oh, forget it. I'm just going to let the $3,000 go. It's not worth it. So, you really have to stop and think of how to address these issues. And then delivery dates, always an important issue. Reps and warranties. I tell clients, I'm like, are you going to get something as is? Or is it going to work for a year? What's the quality? So you really have to look and say, what am I buying, or what am I getting, or what am I selling, so that everyone's on the same page. So that's kind of the theme is a meeting of the minds. Make sure everyone knows what this transaction is going to be doing. If someone comes to me with a problem, they charge me more than they said they would. They didn't give it to me on the day I was supposed to get it, and it was a piece of crap. It broke in a week. So that's the theme. Those are the complaint areas. But then also in your terms and conditions or your client agreement, you can try to limit your liability. So you could say, if everything goes bad, what hits the wall, and we're not getting along anymore. Maybe I even make a mistake and I'm sorry for it. You pay me $2,500, but my mistake maybe cost you $8,000. You could attempt to put a provision in your agreement that says, I'm going to limit my liability, that no matter what liability I have to you, even for my mistake, I'm limited to you, and just all I have to do is return to you the money you've paid for me on this contract. So then you cap your losses as to what you earned on that agreement. So if they paid you $2,500 for this, you basically, in that scenario, you'd return to them the $2,500, as opposed to having unlimited liability for all these different damages that could have occurred because of your breach. So I had a client doing engineering work, and he did make a mistake, and but his mistake, I think they got paid $10,000 on the job, but because his mistake was a foundation issue, it was maybe a $100,000 problem. Because they have to undo everything and start from scratch again. And he had a clause in there limiting his liability to what he got paid. So theoretically, he was only going to have to pay him $10,000 for that problem. You have to be clear, has to be conspicuous. Probably have to have it in bold type. So the other side, it draws attention to them. Because it's a pretty unstandard term. But just because it's unstandard doesn't mean you can't agree to it in a commercial contract. You just usually have to draw someone's attention to it. So they know you're not burying it on page 5 in a footer somewhere. So as long as it's pretty conspicuous, those are things you can do. But you'll probably never do business with that person again. You'll probably never do business with people that they know. So in reality, if you're doing business with a very large, kind of like the white whale kind of client, you're probably going to eat it anyway. But at that point, you have the option to say, nope, I'm not going to give you the extra $90,000, and I never want to do business with you again. Or people because I don't even like you guys. I'm not even going to deal with you people anymore. Then that's a business decision you're making. But if they're going to be a repeat customer of yours, you're probably not enforcing that provision. So it's the practicality of the situation. Hey, I need you more than you need me, so I'm going to have to acquiesce somehow. But then also indemnification, huge deal. You know, I've probably told this story before in presentations, but I had a client, same client, you know, very small engineering firm. They were hired to do a very small but key piece of engineering work on a multi-million-dollar project. And the verbiage of the indemnification provision was, if you as the contractor, the engineer, do something wrong, you're going to have to pay, you know, make whole and pay us, the general contractor, for whatever damages we have. And if me as the general contractor do something wrong on the area where you're doing your work, you have to still indemnify me. So even if the general contractor was wrong, my client was going to be indemnifying them. And I told him, I go, you're getting like $3,500 for this job, potential great, you know, introduction to this huge client. He's like, it isn't worth it. It's not worth me getting such a small fee for such a potential huge liability in the future. And so my client called him up and said, yep, not interested, thanks, sorry. You know, just too much liability, not enough reward. Then the other side goes, well, you gotta be kidding me. You know, no one says no to us. He goes, well, it just isn't worth it. And then they go, well, what would be worth it to you? He goes, get rid of that in language. He goes, you draft, contractor, you draft the language that you want us to have, and we'll agree to it. Because he ended up being that important to their job that they were willing to do whatever it took to work with him. But he was willing to walk away, you know, and he told them that. And because of that, he was able to get some better indemnification language than what was previously provided. So you do have to read your documents. And as an attorney, I think Lee would say the same. We as attorneys don't expect you to understand all this legal mumbo jumbo when you really start getting into some pretty heavy legal documents. You know, that's not what you're in business for, is to understand, you know, what different legal provisions mean. But they're important. Like I had a client, you know, he was selling, you know, products on Amazon. He wasn't doing very well. You know, but then he ended up getting into like almost like a storefront on Amazon where they wanted to sell his product. And he goes, this is great. I'm going to remove my store from Amazon and I'm going to sell through you exclusively on Amazon. No one else on Amazon can sell my product. And he was like, this is great, I'm happy, got his price that he was interested in. And then that company calls up and says, hey, we have one more document for you to sign. Client goes, okay, what, no big deal. So he sends it over to me, he goes, oh, no, don't even review it, we're good. And I already started taking a quick look at it. I go, well, you do realize this document means now you cannot sell anywhere on the internet, not even on your own website. He goes, no. That's not, I go, this is in the first paragraph, you didn't have to get to the end. And he goes, that's not even the deal. He goes, I have a new person on this transaction that's completely wrong. They don't even know what the deal is. I'm like, well, if you sign it, you're not selling anywhere on the internet. So even something that looks relatively, you know, easy to spot, you know, clients miss because they're not in the business of trying to read through all this legal stuff and understand what it means. So, you know, it is a big deal to have documents reviewed, taken a look at. It doesn't have to cost an arm and a leg to have agreements reviewed. Sometimes you can't change them or modify them, but at least you should know what you're agreeing to. You know, and I had one last example. I think we're running out of time. You know, I had a client who was going to sell someone else's product. They were going to be a distributor. They get an agreement from the manufacturer, and it says, as the distributor, you are going to defend and indemnify the manufacturer if anyone ever gets hurt from this product. And so my client sends it to me and says, I've already looked at it, it looks good. Do a quick 10,000 foot once over and be done. Didn't want to spend a lot of money on the legal review. So I go, I'll take a quick look. And so then I call back and I say, hey, just want to let you know that you're going to, if anyone ever gets injured from this product, you're going to defend the manufacturer. She goes, well, why would I do that? I go, I don't know, you reviewed it and said it looked good, so I assume that's something you wanted to do. She goes, no way in the world would I ever want to do that. I go, well, I don't know why you would want to do it, you shouldn't. So then she called up the manufacturer and says, this is backwards. You should be indemnifying me if someone ever gets hurt from your product. And the manufacturer goes, oh yeah, that makes sense, I agree. And now the client's like, okay, now they're trying to screw me. And I go, no, you know what? I think the manufacturer pulled this document off the internet and then just used someone else's deal. You know, who knows what other transaction this was for and what the terms and how they negotiated it. But ultimately, I'm like, because when you download a document off the internet, a legal contract, the pagination and the spacing's all weird. It just doesn't look right. You know, it doesn't flow right. It's just kind of, you know, halting and it's kind of quirky. And that's the way the document was. I truly think, I think they took this document, downloaded it from some other deal they found on the internet, and they just reused it. I really don't think they meant to try to screw you. It was just someone else's deal. And now they know what terms are in the deal that they're asking you to sign. And so you really, but if she did sign it and someone got hurt, she'd be defending the manufacturer, which is insane. But no one should get hurt from the product. But if it does, could infect your insurance if you're primarily responsible. If you show your insurance carrier that you're going to be secondarily liable, the manufacturer is going to indemnify you, could lower your premium. Things do matter when you do these contracts. And I tell people, I go, every paragraph in a contract, no matter what it is there for a reason. Attorneys sometimes, if you want to say, like to get paid by the word, but when ultimately, push comes to shove, this document's going to be analyzed and going to be, you're stuck with it when a court's looking at it. So, it's not a paperweight, but you can draft a contract between you and your customer so you can read it and you can understand it. It doesn't have to be a mortgage that none of it makes sense, or it doesn't have to be your insurance policy that I don't even understand. Like, the attorneys that draft insurance policies, I think, are demented. I mean, you read it and no one can understand it. So, but your contract should be with your client, should be very clear, concise, and I think most people are willing to sign an agreement they can understand. So, question?
Do you have a recommendation for a good length? I mean, some of these things get really out of control, You know what I mean? You click that little
Yep.
box and you say it, but
So the question was, what about if you on the internet, you want to buy a product, you want to download a service, and it said before you can do this, you got to click here and accept the terms and conditions. You click here and accept, don't read them at your own peril. You can't get away and say, hey, I didn't know what that meant because I just decided not to read it when it is there. Now, if the link is broken and you can't read it, then you have an argument that I didn't agree to those terms and conditions. But more than likely, the link will be able to work, and you're going to be bound by those terms and conditions whether you read them or not. And they're all, in general, they are going to be enforceable. But as to a length of a contract, it really has to do with how long you want it to be. Not really an expense issue, but how long you want it to be, and how long you think your customers will read. And if it gets too long, is your customer going to say, okay, where in here are you screwing me? And they're not going to do business with you. You're going to be like, okay, I can do business with A, and they have a one-page, very simple document, or I can do business with you, and you're going to be an 8-page agreement, single-spaced, 8 font, no margins. You're going to look at it and go, dude, I'm not doing business with you, because somewhere in here, you're trying to screw me. Or if you're the only service provider, then they're going to sign it. So it really depends on what your client is going to accept. I think most clients are willing to accept probably a 5-page or less document that has normal spacing and normal margins and normal type font. Because every provision should be pretty clear on what it means. So that's just I can't say I haven't done the research on it, but I would imagine 5 pages or less would be acceptable. So, yeah.
Chris, on that note, we're bound, I'm a CPA, I work for an accounting firm, so we're bound, we have to have engagement letters, right? We get peer reviewed, they come in and they take a look and make sure that we actually have these documents where our clients and us agreed on services and price and things like that. So there's a lot of technical terminology, and some new verbiage came out which made our formal engagement letter 4 pages long. So to your point, right, they're like, where do I sign? They're not reading it. Or then the opposite is they start reading it and they go, what is this crap, right? I don't even know what these promulgated stuff means. I don't know what this is. So we use like a summary page when we're going to start working with a brand new client. We use like a 1-page proposal. And at the very bottom, we feel like we spell it out there, highlighting the terms, the price structure, if fees are going to go up, we're going to talk about it, some highlight items like that. And at the bottom, we state a formal engagement will follow. So to her point about how long you want it to be, we utilize something that is a nice summary. It's really easy to talk through and make sure you're on the same page. And then there's, in our case, and some of you other people in here are bound by, there's regulations and verbiage that has to be included in some type of engagement.
Yeah.
Do you find that to be fairly common or
No.
alternative for many industries where you can summarize stuff, then you're still going to have to go through maybe that 8-page, 8-point font that it's required.
So the question is, what happens if you have a long agreement? Can you somehow shorten that down and then, get a proposal and then ultimately follow it up with a formal agreement? Proposal, letter of intent, very common, and then followed up with another document. So, but in terms of just having a summary page and then have them sign the full agreement, I don't see that very often. Doesn't mean it can't happen or people don't do it. But just I don't see that a lot. I see a lot of letters of intents, a lot of proposals, and then following it up with a more formal agreement later. So.
I just saw one of those was on Hebrew,
Yeah.
I feel like I knew what I was doing when I was clicking.
Yeah. A lot of times people end up doing that. You don't start off doing it, and then maybe you get a lot of questions from customers, and you're like, oh, this is just too much. So I'm just going to create my own summary of the document so I can also post that to hopefully get, take away some of the questions that people always contact. But I apologize. I think we're way over time. But on the table is a business card. Also, I have a little half sheet of paper. I have an email that I attempt to send out once a month. If anyone wants to sign up for that newsletter, feel free to just sign up, and I'll be happy to add you to that. And I thank you. If anyone has any questions, I give all my clients a free 1-hour consultation. Happy to, our potential clients, happy to discuss anything with you. Thank you.